Before you argue, read the actual law. That's advice I wish the authors of our last episode had followed. If you haven't seen part 1, go check it out on The Undercut. Now let's get into Oklahoma v. Drummond. The Archdiocese of Oklahoma City and the Diocese of Tulsa wanted to launch a Catholic virtual charter school, St. Isidore of Seville, to serve rural areas. My first reaction? That sounds dumb as hell. Why would a religious institution want to join the public school system? Yes, charter schools operate with more flexibility than traditional public schools, but they're still publicly funded and subject to the same constitutional rules around religion. Some argue the motivation was money, but religious schools already qualify for federal funding for things like free or reduced lunch, special ed grants, and other programs under No Child Left Behind, and every student succeeds. So the "we needed funding" excuse doesn't hold. Anyway, Oklahoma Charter School Board approved the contract, but omitted legal language that prohibited religious affiliation. That move violated the Oklahoma Constitution, the Oklahoma Charter Schools Act, and the Establishment Clause of the U.S. Constitution. Now, the case hinges on two major legal questions, which I've paraphrased. One, if a public school receives state funds to provide public education, does its decisions count as state action? And two, does the First Amendment prohibit or the Establishment Clause require the state to exclude religious schools from its charter program? Here's my take. If the state is paying for it, the school isn't truly private anymore. It's acting on behalf of the government. And when a government funded entity promotes religion, that's a problem. It's settled precedent. Under the Lemon test from Lemon v. Kurtzman, the government can't be excessively entangled with religion. And funding a religious charter school, that's not entanglement, that's a bear hug. So yes, this case does look like a religious institution trying to use First Amendment protections to bulldoze right over the Constitution. But here's where I take issue with the article from the Hechinger Report. Mahmoud v. Taylor is about parental rights, about whether the government can compel young children to participate in lessons that violate their family's religious beliefs. You may not agree with those beliefs. I don't always either. But the right to raise your child with your own values, that's worth protecting. On the other hand, Oklahoma v. Drummond is, frankly, some First Amendment cosplay. The point is this: these two cases are fundamentally different. Conflating them just because religion appears in both headlines, that's lazy and misleading. If I can explain both cases in 6 minutes, the authors could have dug a little deeper in their article. They should have argued with the law, not with the vibe.